Hello and good evening, everybody. My name is Richard and I'm the Executive Director for Korean American Civic Empowerment. Thank you everyone for coming tonight. Don't mind the rain, it's actually pretty soothing. And for today's subject matter, maybe fitting as well. So our high school internship program has been running for the past 21 years. And we have been raising the next generation of Korean American leaders in civics, in law, in business, in different areas, arts, music, just name it. We try to cultivate the different things that our interns already have in them and try to direct it towards something bigger that they are capable of achieving as they grow up into adults. We provide a lot of opportunities. We do voter registration drives. We do things like our Trial of Reenactment series that we do alongside with AABANY that has graciously helped prepare these scripts and make them widely available for all of us to learn more about Asian American history. So our interns have been working for the past 2 or 3 months going over the script, practicing the lines, and really learning and researching the history behind tonight's reenactment. So our interns will be going more into about the substantive matter of tonight's reenactment. We hope that this is a time of learning for us to build community and ultimately to help work together to pave a path towards a brighter future. So I would like to invite to the stage Executive Director Young Chen from the Asian American Bar Association of New York. Let's give a warm round of applause.
Thank you, Richard. It's great to be here. Thank you all for coming out on this rainy night. I'm very excited that KACE is putting on this reenactment. I understand this is the third time that KACE is putting on one of the AABANY trail reenactments. AABANY, in case you didn't know, stands for Asian American Bar Association of New York. A little bit about AABANY. We were founded in 1989. We are a membership organization that represents the interests of Asian American lawyers, judges, law students, prosecutors, anybody and everybody who is involved in law. They don't have to be Asian American to join. We're open to all, but most of our members are Asian American. We actually are very proud to be the only Pan-Asian Bar Association in New York City and New York State. And that means we have members that are Chinese American, Japanese American, Korean American, South Asian, Pacific Islander. So it covers the whole base. So AABANY began doing these trial reenactments back in 2007. And it was started by the Honorable Denny Chin, who currently is a senior judge in the Southern District, in the Second Circuit, which covers New York and Connecticut and one more state, which escapes me right now. He and his wife, Kathy Hirata Chin, who was a partner at a couple of prominent law firms, they led AABANY in researching, writing, and then performing these scripts. And Judge Chin got the idea from a group called the Federal Bar Council. They have something called the Inns of Court, and so a group of judges together with attorneys get together, and they actually would do trial reenactments of famous cases. The first one that Judge Chin brought to us was in 2006, and we did it as part of a Northeast Regional Conference here in New York that AABANY was hosting, and it was a trial of Julius and Ethel Rosenberg, who were wrongly accused of being spies during the Cold War and were executed. And it was very successful. We had pretty much an Asian cast performing. I was part of that cast. And then the year after, Judge Chin and Kathy thought, why not do something like this but featuring Asian Americans? Because the fact is, a lot of people just don't know Asian American history. They don't know how much Asian Americans contributed to the development of history in the United States socially, politically, legally. So this is an example of that. Right now, we have this big issue you may have heard about birthright citizenship, right? It stands for the idea that anyone born in the United States is a citizen automatically. That right is being challenged right now. That right was brought about by a famous case that went all the way up to the US Supreme Court called Wong Kim Ark, a Chinese American man. This reenactment, Constitution in Time of War, the trial of Minoru Yasui, was the very first Albany reenactment that we did in 2007. And it was a case that was discussing the constitutionality of the executive order signed by President Roosevelt that led to the internment of over 100,000 Japanese American citizens without any due process, without any trial. Just because they were Japanese American, they were suspected of being traitors to the US and sent to concentration camps for the whole war. And Minoru Yasui is one of the brave people that challenged that order. There were a couple of other famous and brave Japanese Americans, Korematsu and Hirabayashi, that also challenged it. But at the time that we wrote this script, we were not able to find the transcripts, and the reenactments were about finding the original historical transcripts and using them to tell these important stories that nobody knows about. With that background, I commend these students for bringing back and telling these very important stories. I'm sure this will be a very powerful reenactment, and I'm glad you're here to experience it. So I'm very excited and eager to see it as well. So at this point, I think I'll pass it on to one of the students who is going to lead us off. Who is that going to be? Here she is. So please enjoy the reenactment.
Hello and good evening. My name is Pobin Shim, and I am one of this year's KACE grassroots interns. Welcome to this year's trial reenactment titled The Constitution in a Time of War, the Trial of Minoru Yasui. I would like to extend our gratitude to the Asian American Bar Association of New York, JuryGroup, Judge Denny Chin, Kathy Hirata Chin, the Office of the Queensborough President Donovan Richards Jr., KCMB-TV의, and all those involved in making tonight's performance possible. Thank you. KACE advocates for fair representation of the Asian American community here in New York, which includes educational programs such as tonight in teaching about Asian American, Native Hawaiian, Pacific Islander history. As young Korean Americans, we are honored to be part of teaching Asian American history as we prepare to go out and make history ourselves. Tonight's performance is about a trial that took place during World War II. This was a time of severe anti-Japanese sentiment in the United States because of tense geopolitical conflicts, which led to many unjust state actions, most notably the internment camps and implementation of curfews upon Japanese Americans. Many Japanese Americans attempted to challenge the constitutionality of these unjust laws. One such person was Minoru Yasui, a US-born Japanese American lawyer. This case, as did others, went up to the Supreme Court of the United States that ruled in favor of upholding the curfews and internment camps throughout World War II. The basic human rights and humanity of Minoru and Japanese Americans were denied. Much of the vocabulary used in tonight's performance includes offensive language and terms used against and towards Japanese and Asian Americans. This reenactment serves not only as a means to teach Asian American history, but also a reminder that the legality of a law does not always make it just. December 7th, 1941, Japan attacks Pearl Harbor. February 19th, 1942, President Roosevelt signs Executive Order 966, authorizing the designation of military zones from which any and all persons could be excluded. Early March 1942, General John L. DeWitt issues public proclamations numbers 1 and 2, designating military areas along the West Coast and warning of future evacuation. March 21st, 1942, Congress passes Public Law 503, criminalizing disobedience of any such military proclamation. March 24th, 1942, General DeWitt issues Public Proclamation number 3, which established a nighttime curfew and 5-mile travel ban to take effect on March 48, 1942, imposed on all persons of Japanese ancestry. March 28, 1942. Within hours of the curfew taking effect, a Japanese American lawyer, Minoru Yasui, deliberately violates curfew in Portland. June 12, 1942. One-day bench trial of Yasui takes place before Judge Fee. November 16, 1942. Judge Fee finds the curfew order unconstitutional as applied to U.S. citizens, but constitutional as applied to Yasui, on the ground that Yasui is an alien. November 18, 1942. Yasui is sentenced. June 21, 1943. Yasui's conviction is upheld by the U.S. Supreme Court on the ground that the curfew was constitutional as applied to American citizens. The opinion in Hirobayashi is released on the same day. December 18, 1944. Decisions in ex parte Endo and Korematsu are handed down by the Supreme Court. February 19, 1976. President Ford formally rescinds Executive Order 96-6. November 10, 1983. Federal District Judge Marilyn Patel of the Northern District of California grants Korematsu's writ of error coram nobis, overturning his 1944 conviction. 1984. The District Court in Oregon vacates Yasui's conviction, but denies the declaratory relief that he sought. Yasui appeals to the Ninth Circuit. November 12, 1986. Yasui dies before his appeal could be heard.
On February 19, 1942, 74 days after the bombing of Pearl Harbor, President Roosevelt signed Executive Order 9066, authorizing the Secretary of War to designate military zones from which any and all persons could be excluded. Eventually, some 120,000 persons of Japanese ancestry, 2/3 of them U.S. citizens, were removed from their homes on the West Coast without any due process or individualized consideration and placed in internment camps. The relocation process began with orders imposing a nighttime curfew on all persons of Japanese ancestry. On March 28, 1942, within hours after the curfew took effect, a young Japanese-American lawyer, Minoru Yasui, began walking the streets of Portland, Oregon. Intent on challenging the legality of the military orders, he walked for 3 hours trying to get arrested. He even asked his secretary to call the police to say that there is a Japanese walking up and down the street. Go arrest him. Police officers, however, told him to run along home. Undeterred, he finally went to a police station where he demanded to be and was arrested. Yasui was the first person to challenge the military orders. He was indicted for violating the curfew and was prosecuted in federal court. 2 other Japanese American citizens were prosecuted for violating military orders, Fred Korematsu and Gordon Hirabayashi. A Japanese American woman, Mitsuye Endo, filed a petition for a writ of habeas corpus to challenge her internment. All 4 cases reached the United States Supreme Court.
Yasui waived his right to a jury, and the case was tried to the Honorable James Auger Fee on June 12, 1942. Judge Fee asked 8 of Portland's leading attorneys to attend the trial as friends of the court to provide advice on the constitutional issues. 9 witnesses, including Yasui, testified. The government was represented by Carl Donaugh, the United States Attorney for the District of Oregon. He was accompanied by Charles Burdell, a special assistant to the Attorney General from Washington, D.C. Yasui was represented by Earl Bernard, a distinguished Portland lawyer. Bernard was not known for taking on liberal cases, but he was an acquaintance of Yasui and took an interest in the case. He would represent Yasui all the way to the Supreme Court. This morning, we will reenact portions of the Yasui trial for you. Other than some editing for length and the addition of some commentary, the words that you will hear are the actual words spoken at the trial more than 65 years ago. Ladies and gentlemen, the trial of Minoru Yasui.
All rise for the Honorable Justice Fee. You may be seated.
United States of America versus Minoru Yasui, defendant.
The defendant is ready for trial, Your Honor.
The government is ready, Your Honor.
You may proceed.
It was undisputed at trial that Yasui had knowingly violated the curfew. Rather, the principal issue was a legal one, the constitutionality of the curfew order. Yasui was a U.S. citizen, and the curfew order applied to all persons of Japanese ancestry, including American citizens of Japanese descent. The curfew order did not, however, apply to any other American citizens. In its opening statement, the government did not address the constitutionality of the curfew, but alluded to two other lines of attack. First, Yasui had forfeited his American citizenship by his actions on behalf of the Consul General of Japan. And second, the military orders were necessary because the racial characteristics of the Japanese predisposed them to sabotage and subversion.
Your Honor, the indictment charges the defendant Minoru Yasui with having failed to comply with Public Proclamation Number 3. The government charges that the defendant, a Japanese by reason of being a person of Japanese ancestry, was absent from his place of residence on and about March 28, 1942, by failing to comply with orders requiring that all persons of Japanese ancestry be at their places of residence from 8 p.m. until 6 a.m. the following day. The facts are that he appeared here in Portland after the 8 o'clock hour, walking into the police station at 11 p.m. or thereabouts, and was taken into custody by the Portland Police Department. That, in brief, Your Honor, is the nature of the offense charged. The government is also prepared to introduce other testimony concerning the defendant, and if the opportunity presents, the government has information as to certain beliefs which may be shared by persons of Japanese ancestry, should such evidence be pertinent to the case in hand.
If Your Honor pleases, the evidence in this case will show that Mr. Yasui is an American citizen, and we will introduce evidence to show that he has never been divested of that citizenship, and that at the time of the alleged commission of the acts charged in this indictment, he was an American citizen and entitled to all privileges and amenities that attach to that status. It will be our contention that this proclamation as applied to this defendant, and indeed the executive order of the President of the United States, are void as a violation of the constitutional rights that attach to citizenship. And it will be our further contention that the war power of the government of the United States does not diminish constitutional guarantees, particularly the guarantees attaching to the citizenship under the 4th, 5th, and 6th Amendment of the Constitution of the United States.
Proceed.
The government called as its first witness Sergeant William Moss of the Portland Police Department.
Did you at any time on March 28, 1942, have occasion to see Minoru Yasui, the defendant in this case?
Yes, sir.
Whereabouts did you see him?
He came into the police station.
At what time?
11:20 p.m.
What took place when he came into the police station?
He came in and he said that he wanted to be arrested. He wanted to test the constitutionality of the aliens curfew law. He said that he had been down in the North End. He asked several policemen down there to arrest him, but they wouldn't do it, and so he came into the station.
Did you have any further conversation with him?
He told me he was an American citizen. He lived at Hood River, and he wanted to test his case for the Japanese.
And he was placed under arrest, was he?
Yes, sir.
Have you had occasion at any time to talk to him again?
No.
That is all, Sergeant.
No cross-examination.
The government next called Special Agent Vincent Quinn of the FBI. Quinn had interviewed Yasui twice. First, in January 1942, shortly after the declaration of war against Japan, when Yasui visited the FBI. And second, in April 1942, a few days after Yasui was arrested for violating the curfew.
Will you state when you spoke with the defendant, Minoru Yasui?
On January 12, 1942, Mr. Yasui visited our office, at which time he advised that he was returning from Chicago, Illinois, where he had been employed by the Japanese consulate. He exhibited to me a card verifying that he was registered with the Department of State as an agent for a foreign principal. Mr. Yasui told me that he withdrew the registration on December 8th. He also exhibited to me a certified copy of a birth certificate, which showed me that he was born in Hood River, Oregon. Mr. Yasui also advised me that he was a second lieutenant in the United States Army and that he expected to report for a physical examination around January 19, 1942, at which time he thought he would be inducted into the active forces of the United States.
When did you speak with the defendant again?
On April 3rd, I visited at the Portland Police Department after our office had been advised that Mr. Yasui had surrendered himself.
Did he make any statement as to the nationality of his parents?
Yes, he told me they were Japanese aliens.
Do you know how long the family or the parents of the defendant have lived at Hood River?
That was not discussed, although Mr. Yasui told me his father was not at Hood River at the time.
Was any information given you concerning the defendant's education?
Yes, he stated that he had graduated from the University of Oregon. He stated that he had been admitted to practice before the local courts and that he was an attorney at law.
Now, you mentioned that he withdrew from his appointment with the Japanese Consul General on, did you say December 9th?
December 8th, 1941, the day after the declaration of war with Japan.
You testified a moment ago about the defendant holding a commission in the United States Army. Do you know how he acquired that commission or when?
He advised me that he acquired the commission by taking a reserve officer's training course while attending the University of Oregon's ROTC course.
And he still held that commission at the time you talked with him?
He stated that he did.
That is all, Mr. Quinn.
Just a moment. I want to ask you a question or two. Mr. Quinn, your first contact with this man was on January 12th, was it?
That is right.
Did he come to your office voluntarily, or had you sent for him?
He came to the office voluntarily.
Did he state what the purpose of his call was?
He did.
And what was it?
He stated that he came to the office to inquire as to whether or not he could assist his father in any way. His father at the time was in federal custody. He had been apprehended as an alien enemy.
Well, you mean his father had been taken into custody up at Hood River as an alien enemy?
That is right.
And after discussing that matter, did Minoru Yasui tell you that he had been employed in the Japanese consul office at Chicago?
That is right.
Did he tell you in what capacity he had been employed?
He stated that he was doing general secretarial work and acting as a clerk.
Did he tell you when he had resigned this position in Chicago?
Yes, he did. He stated that he had notified the Secretary of State on December 8th, 1941. He stated that his father has asked him to do so.
I think that is all, Mr. Quinn.
Quinn was not asked about the circumstances under which Yasui's father had been taken into custody. The attack on Pearl Harbor had unleashed an immediate storm of anti-Japanese prejudice and resentment. Well before the military orders were introduced, FBI agents swept through Japanese American communities in California, Oregon, Washington, and Hawaii, arresting hundreds of Japanese Americans. Yasui's father was among them. Community leaders, teachers, religious figures, and businessmen suspected of having ties to Japan were rounded up, questioned, and detained. As the anti-Japanese sentiment built, Japanese Americans, citizens and non-citizens alike, lived in a state of fear. Ray Mize, another FBI agent, testified next. He had interviewed Yasui in March 1942, 2 days after his arrest. Mize testified that Yasui made two incriminating statements. First, he said that he was sorry for violating the curfew, and second, he agreed that the government's decision to intern Japanese Americans.
Why did you talk to him?
At my request, Mr. Yasui called at the office to be questioned as to the violation of the curfew regulation.
What was said?
Mr. Yasui discussed with me a little bit of his background. He then stated that he had given himself up voluntarily at the police station to test the constitutionality of the regulation. He stated that he was an American citizen of Japanese descent, and he felt that the regulation was unconstitutional because it discriminated against one group of United States citizens and did not apply to all citizens, and he felt that the large majority of the Japanese citizens in this country were loyal to this country and wanted to do their part in the present war.
What else was said?
I discussed with him briefly the war itself and asked him whether he felt that the Japanese government had acted fair and square in the present war, and he said frankly that he did not think that the Japanese government had. And as a result, American citizens of Japanese descent in this country were being unjustly discriminated against and would suffer for the crimes of another.
Was there anything else?
I asked him if he felt that during these particular times, his action in violating the curfew would reflect very favorably on the Japanese colony, and Mr. Yasui stated that when thinking it over, he did not think that it would be a very good reflection, and that in a certain sense, he was sorry that he had taken that action.
May it please the court, Your Honor.
The witness suggests, Mr. Dono, that he did not complete his answer, apparently that he had forgotten something.
Oh, I see.
I have another point I would like to bring up. I asked Mr. Yasui what he would do if he was in charge of the West Coast here, and an invasion of this country was very probable, and I asked him what he would do to be very sure that the internal security of this country will be absolutely protected, and Mr. Yasui said, well, that is a rather hard question at this time, but after due hesitation, he finally stated that, I feel I would intern all Japanese aliens and Japanese citizens. That is all.
Just one question, Mr. Mitz. Did I understand you to say that he told you the reason why that he had resigned was that he felt that he cannot be a loyal American and keep his employment at the Consul General's office?
He implied as much, Mr. Bernard.
That is all.
We turn now to the testimony of another FBI agent, Alan Davis, who was present when Mize interviewed Yasui in March.
Will you state the nature of the conversation you had with the defendant at that time?
Mr. Mize has been discussing affairs with Mr. Yasui when I entered the room, and I had previously known that Mr. Yasui and I started talking with him. Regular conversation. We were discussing the patriotism of the Japanese, and the question was asked by Mr. Mize as to the loyalty of the Japanese in Oregon. Whether Mr. Yasui could say that he could depend upon them if they were an attempted invasion in this country, whether he would detain all the Japanese, including the aliens, as well as the American-born Japanese citizens. Mr. Yasui more or less hesitated in answering the question, but he stated quite definitely that he would intern not only the aliens, but also the American-born Japanese in that case.
You had known the defendant previously, had you?
Yes, sir.
At the University of Oregon?
Law school and prior to our entrance in law school, yes, sir.
Now, the circumstances under which Mr. Yasui talked with you and with Mr. Mize were what? Was there any discussion at all as to what consideration he would receive by you should he testify or speak to you about this matter?
No, sir.
No threats or
No, sir.
duress of any kind?
No, sir.
Promises?
None.
He seemed to be talking freely and with ease to you?
Yes, sir.
Now, as I understand it, Mr. Davis, you came in March 30th when Mr. Yasui had already been engaging in a conversation with Mr. Mize.
Yes, sir.
And something came up about locking up the Japanese to prevent sabotage?
I did not mention sabotage, no, sir.
Locking them up for what purpose?
Well, for protection of this country.
In what way?
Well, I would assume that he meant that he would be unable to trust the Japanese on the West Coast.
Pardon me, I am asking you what he said about that.
Well, he stated that if he had anything to do with it and there might be an attempted invasion of this country, he would detain aliens as well as the citizens.
And how did he come to say that? Do you remember? What brought that up?
The question was asked by Mr. Mize, as I recall, that if he should be in charge of military affairs on the West Coast, what he might do under those circumstances.
Now let me refresh your recollection. Isn't this about what happened, that somebody was pressing the subject as to how the commander of the army would be absolutely sure of the protection of the country without locking up the Japanese? And Mr. Yasui said, well, if you wanted to be absolutely sure, I suppose they would be locked up. And that someone remarked, to the same extent that if God wanted to be absolutely sure that there would be any wars fought, why? We should just kill off all the human beings. Now, does that refresh your recollection any?
No, sir.
I see. That is all.
The government concluded its case by calling two witnesses who had been members of the Alien Enemy Hearing Board in Oregon. They had participated in a hearing in Fort Missoula, Montana in February 1942 to determine the fate of Yasui's father as he was detained as an enemy alien. Now the government sought to use Yasui's testimony at the hearing to show that he was disloyal. The second of these witnesses was Leslie Scott, the treasurer of Oregon.
Have you had any connection, Mr. Scott, with the alien enemy situation in Oregon?
A member of the Alien Enemy Hearing Board for the state.
And in connection with your duties as a member of the Alien Enemy Hearing Board, have you before today seen the defendant?
At Fort Missoula on February 3rd, at a hearing of the board, Mr. Yasui testified on behalf of his father.
Do you recall, Mr. Scott, what the defendant said with respect to his own activities and employment?
He stated that he had been in the service of the Japanese Consul General in Chicago as secretary to the Consul General and as a public relations agent or representative.
Was anything said in regard to his duties as public relations representative?
He was to attend to the correspondence of the Consul General, he, Mr. Yasui, having ready command of English, and he was to make speeches on subjects approved by the Consul General.
Was anything said as to how many speeches were delivered?
I don't know how numerous they were. I gained the impression that they were rendered on a number of occasions before groups of American citizens.
Did he say what the subjects of these talks were?
They pertain to the conduct of the Japanese war against the Chinese, justification of Japanese policy towards China, and justification of the war against China.
Was there any discussion before your board concerning how the defendant obtained his position with the Japanese Consul General's office?
Yes. Mr. Yasui said that he had graduated from the University of Oregon Law School, and his father was desirous of making a connection for him with the Japanese Consul General. The father wrote a letter to the Consul General describing the qualifications of the young man.
I take it, then, that his employment with the Japanese Consul General was on a basis of the recommendation of his father. Is that correct?
That was the distinct impression that the board received.
And the father was also before your board?
The father was before our board at the time, and the son appeared as friend or relative or advisor of his father.
And what was the nationality of the father?
The father is a native-born Japanese. The son was born in the United States. He was 25 years of age last February. The father had given the son the advantage of an American education.
Following the Alien Enemy Board hearings in Missoula in February 1942, Yasui's father was classified disloyal. He was kept in detention until 1945.
The government concluded its direct case by offering certain exhibits. Dono first read from Public Proclamation No. 1, which declared the entire Pacific coast of the United States a military zone because it was particularly subject to attack, to attempted invasion by armed forces of nations with which the United States is now at war, and to espionage and acts of sabotage. Dono then read from Public Proclamation No. 3.
From and after 6 a.m., March 27, 1942, all alien Japanese, all alien Germans, all alien Italians, and all persons of Japanese ancestry residing or being within the geographical limits of the designated areas shall be within their place of residence between the hours of 8 p.m. and 6 a.m., the hours of curfew. The government rests, Your Honor.
The defense called only one witness, Minoru Yasui himself.
Your name is Minoru Yasui,
That is correct.
and you are the defendant in this criminal action.
I am, sir.
Have you ever in your life received any questionnaire from the government of Japan relative to your willingness to engage in any military service or activity in Japan?
I received no such questionnaire from the government of Japan.
Did you ever take a trip to Japan?
Yes, sir, I did.
And when?
To the best of my recollection, it was in 1925 when I was about 8 years old. We left to the United States sometime in July and returned approximately in September. It was just a summer vacation.
Were you asked when you were over there to take any oath of allegiance or do anything towards taking out citizenship in Japan?
Object to that as immaterial, Your Honor. The objection is sustained.
I wish to make an offer of proof, Your Honor. I offer to prove that this witness that while he was in Japan at the time, he did not take any oath of allegiance to Japan or take any steps to become a citizen of Japan.
He couldn't. He was a minor. He had no election until after he had passed the age of 21.
By the way, this trip to Japan when you were about 8 years old, were you ever in Japan after that?
No, sir, I have never been in Japan since that time.
Ever resided in any foreign country at all?
No, sir.
Have you voted in the United States?
I have, sir.
Have you ever voted in any other country?
No, sir, I have not.
Now, what date did you finish law school, Mr. Yatsui?
If the court please, I object to that as incompetent, irrelevant, and immaterial.
Oh, I think it is preliminary. He may answer.
When did you finish law school?
In June of 1939.
And when did you go to work for the Consul General office in Chicago?
The following year in April 1940.
And what did you do in that meantime?
Well, pending the results of the bar examination, I helped as a ranch hand on my father's farm. In approximately September, we heard the results, and having completed the bar, I attempted to practice law both in Hood River and for a short while in Portland, Oregon.
Bernard then asked Yasui to explain his work at the Japanese Consul General, seeking to dispel the notion that Yasui was a disloyal American or a Japanese loyalist.
Now, tell the court how you secured this position.
There was a letter written by my father to the Consul General stating that I had graduated law school. I secured letters of recommendation from Dean Wayne L. Morse of Oregon Law School and from people in Hood River and in Portland. Because there was a need for a man who could speak English as well as Japanese, and I suppose also because of my record at the University of Oregon, I was selected.
And when did you go to Chicago?
I arrived in Chicago on April 1st, 1940.
Were you required at the time to take any oath of allegiance?
I was not required.
Objected to, Your Honor, as incompetent, irrelevant, and immaterial.
Well, I'm not sure that it is incompetent if he took an oath of allegiance after he arrived at the age of majority.
Well, Your Honor, the defendant is charged with violating Public Proclamation No. 3, which applies to all persons of Japanese ancestry residing or being within the geographical limits of Military Area No. 1. It is not limited to alien Japanese.
I know it is not, and that is what makes me doubt its constitutionality. Therefore, I hold that the proof is competent to establish whether there be citizenship, notwithstanding that your indictment did not allege that this man was a citizen. Proceed.
Would you read the witness the question, Mr. Reporter?
Were you required at that time to take any oath of allegiance?
I was not required to take any oath of allegiance when I began my employment with the Consulate General in Chicago.
At any time during your employment?
No, sir.
Now, will you please state the court your duties in that position and what you did?
I was employed as a general secretary in charge of the correspondence. There was an American fellow by the name of Bob Murphy and myself. We received the morning mail, submitted them to the Consul General, and the Consul General would submit one of the letters to either Murphy or myself to answer. Because of our facility with the English language, also on various occasions, the Rotary clubs and civic organizations would call upon the consul to send a man to explain the position of Japan in the Far East. Or perhaps some club or organization would want to know about flower arrangements. I did go to such meetings to make such speeches.
I believe one of the witnesses testified that you said up in Minnesota that you were first a secretary and then some sort of public relations man.
Well, as I recall my testimony at Fort Missoula, no such statement was made that I was ever a public relations man. However, I did testify, as I do now, that I did make certain speeches there, if that be so constructed as public relations.
And did you make speeches with regard to Japan's position in the war with China?
Yes, I did, sir.
When did you hear of the attack in Pearl Harbor?
On December 7th, 1941.
When did you resign your position?
As I recall, on the 8th day of December, 1941.
And why did you resign?
Because I felt that as a loyal American citizen, I could not be working for the Japanese consulate after the declaration of war.
Did you receive that advice from anybody?
No advice that prompted me to so act, except possibly a telegram from my father, that he wired me now that his country...
You can't state the contents of it. I would like this wire marked for your identification. Is this the wire you received from your father?
Yes.
I would like to offer the wire in evidence.
Objection as immaterial. We also object that it is hearsay and self-serving.
The court has ruled that it is pertinent to show whether this defendant is an American citizen. That depends on the question of his intention. The objection that this is self-serving goes simply to the question of weight rather than admissibility. I think it may throw some light on his intention. It is admitted.
This is a telegram dated December 8th, 1 a.m., Hood River, Oregon, addressed to Minoru Yasui. It reads, "As war has started, your country needs your service as a United States Reserve officer. I, as your father, strongly urge you to respond to the call immediately. What did you do about offering your services to your country, Mr. Yasui?"
Before that...
Just a moment. I think that is objectionable.
Well, I don't know what your honor has in mind. I'm offering it also as to his intentions.
You may ask him what he did toward offering his services to Japan or the United States, whichever you wish.
All right, I will confine to the United States. What did you do towards offering your services to the United States?
I immediately wired headquarters at Portland, Oregon, offering my immediate services.
Have you ever been called to active service, Mr. Yasui?
No, sir.
Are you willing to go in active service at any time?
I am, sir.
In fact, after he had resigned his position with the consulate in Chicago, Yasui reported for duty in Fort Vancouver in Washington, across the Columbia River from Portland. After just one day, however, he was ordered off the base because of his ancestry. He would go back to the fort 8 times trying to serve, but each time he was turned away. Bernard moved to Yasui's statements to the FBI agents.
Now, when did you return to the West?
I returned to Portland on January 12, 1942.
When did you go up to the FBI office?
On the afternoon of my arrival here in Portland.
What was your purpose in going to the FBI office?
The FBI special agent in Chicago suggested it would be wise for me to keep in touch with the FBI agents in Portland.
And it was for that reason that you went up there?
And incidentally, to inquire about my father, whom I had not seen for the last 2 years.
Now, you had a conversation with Mr. Mize. State your version of that conversation.
In general, the conversation as reported by Mr. Mize is correct. We did discuss our school days, and then Ray Mize posed the question that if I were the commander-in-chief, knowing that an imminent invasion was possible, how would I be absolutely sure that the security of this country would not be in danger? Well, the only logical answer would be to intern the Japanese. However, I asked the academic question, If Mize himself was God Almighty, how would he absolutely be sure to prevent wars? Mize answered that he would destroy the people. Of course, this is the extreme view, but we did converse along those lines.
Well, at the time, do you know whether there had been any orders removing the American citizens?
At that time, there was no such order.
And this was sort of a academic discussion.
It was a hypothetical question at the time. Yes, sir.
I believe that Mr. Mize also said that you were sorry that you had taken the action that you had.
The question was whether I believed in any repercussions that would happen from my testing the constitutionality of the Curfew Act. And I believe that possibly there would be repercussions that would be harmful to the Japanese colony.
And what did you have in mind when you made that last statement?
Well, there is always a possibility of more stringent regulations being imposed. And secondly, the public resentment against anyone possibly testing the constitutionality of an army order.
Now, have you ever obtained or attempted to obtain naturalization in any foreign state whatsoever?
No, sir, I have not.
Have you ever taken an oath or made a declaration of allegiance to a foreign state?
No, sir.
Have you ever entered into or served in armed forces of a foreign state?
No, sir, I have not.
Have you ever deserted the military or naval services of the United States?
No, sir, I have not.
In time of war or otherwise?
No, sir.
Have you ever committed an act of treason or attempted by force to overthrow or bear arms against the United States?
No, sir.
And as far as you know, have you ever, either intentionally or unintentionally, done any acts to renounce citizenship in the United States of America?
To the best of my knowledge, I have never renounced my American citizenship.
The relocation and internment orders had resulted in many Japanese American families being torn apart, as in many instances, family members were dispersed to different camps. Bernard concluded that the direct examination by Yasui about his family.
Where are you residing now?
Presently, I am at the WCCA Assembly Center at North Portland, Oregon.
That is where the Japanese are being detained 24 hours a day.
That is correct, sir.
Do you know where your father's residence is?
I understand it to be at Camp Livingston, Louisiana.
And where is your mother?
I live in Pineville, California.
Have you got some sisters?
Yes, sir. One sister. I believe she is now in Denver, Colorado.
She was younger than you.
Yes, sir. She just graduated at the University of Oregon.
We move to the government's cross-examination. After a few background questions, Donald examined Yasui at length about his ability to speak Japanese and his activities with other Japanese Americans. These seemingly innocuous matters were an important part of the government's strategy, as the government will later argue to the Supreme Court that the Japanese language schools and Japanese organizations and societies were used to indoctrinate the Japanese on the West Coast with Japanese nationalism.
Do you speak Japanese?
I do, sir.
And where did you learn to speak Japanese?
I learned it from my parents.
Do you speak Japanese in your home?
To a certain degree, yes, sir.
Have you spoken Japanese for a good many years?
Ever since I could recall.
Ever go to a Japanese language school or a Japanese school of any kind?
Yes, sir, for 3 years.
Whereabouts was that?
At Hood River, Oregon.
What was the name of that school?
I think they called it the Japanese Language School.
Did you have any Japanese societies or organizations which you attended in Hood River or elsewhere?
By Japanese societies, what exactly do you mean?
Organizations or associations of Japanese people?
There is a Japanese Methodist church, of which my father and mother are members, which I attended on Sundays, and the Japanese American Citizens League, and that's about all.
Ever belonged to any Japanese fencing clubs?
No, sir.
Or riding clubs of any kind?
No, sir.
Are you a member of the Methodist Church?
I am, sir.
In the Japanese language school, what language is used there?
Both English and Japanese.
But you went there to learn and become proficient in Japanese, is that it?
To attempt to become proficient, yes.
Dono then turned his attention to Yasui's employment at the Japanese consulate and his father's involvement in the community. Although the government suggested that Yasui's work for the Japanese consulate and his family ties to Japan evidenced his disloyalty to the United States, it was only after Yasui had been unable to find employment as a lawyer that his father helped him obtain the consulate position in Chicago. Moreover, although Yasui's father was a leader in the Japanese American community in Oregon, he had also been active in a largely white apple growers association in Hood River.
You didn't know the Japanese consul general directly?
No, sir.
Then your contact with him was through whom?
My father.
Did your father and the consul have any close contacts so far as you know?
Well, as I understand, the Hood River community has about 500 Japanese, and every consul here goes up to Hood River about once a year to contact various people. And my father, through those contacts, has undoubtedly met the Japanese council.
Your father has been rather active in the Japanese colony in Hood River, hasn't he?
He has been very, very active in advancing the betterment of that community. Yes, sir.
Contributed any money to the Japanese War Fund?
As to that, I have no knowledge.
Well, isn't it a fact that your father testified in your presence before the Alien Hearing Board that he had contributed money to the Japanese War Fund?
We will object to that, Your Honor. This young man would not be bound under the circumstance they're prevailing by anything that his father said in that hearing.
No, I don't think it is binding. I will sustain the objection.
Were you present at the ceremony in the Japanese consul's office in Portland when your father was given a high honor by the Japanese government in 1940?
No, sir, I was not.
You are aware of the fact that he received recognition by the Japanese government.
For the work that he had done in promoting better relations between the Japanese and Americans in Hood River Valley, yes.
Now, in regards to your work in Chicago, you had occasion to deliver speeches occasionally at the request of the Consul General.
That is correct, sir.
And where would you receive your directions to deliver a speech at a certain time?
From the Consul General.
Donan then turned to the relations between the United States and Japan and the hostilities that had arisen in China.
Well, now, when you went to work for the Japanese government through the Japanese Consul General, were you aware, were you not, that conditions between Japan and the United States over a number of years had caused considerable comment and difficulty, indicating the possibility of strained relations between this country and Japan? You knew that, did you not?
Yes, I did.
Did you not know that even as far back as 1937, an American gunboat and American sailors had been fired on by the Japanese, and that the series of companion acts in China where American citizens were involved had caused strained conditions between those two countries?
Yes, I understood all of those things, and it was my purpose when I worked for the Consul General of Japan possibly to work for a better relationship.
But you testified that you had no discretion in what you did, that you did what you were told to do by the Japanese consul?
That is correct.
And you did not exercise your opinions as an American citizen, but did what the agent of the Japanese government asked you to do and said what he asked you to say?
That is correct. To bring out what the Japanese government had to say to the attention of the American people, to express it so that it could be understood.
And well knowing that the attitude of this government and the American people was contrary to the policy of Japan that you were defending, speaking about?
Because I thought it was my contribution to the preservation of peace. As it turned out, we were wrong, but that is my sincere purpose in working for the Consulate General of Japan.
That is all.
Just as it appeared that Yasui's testimony was complete, Judge Fee interjected and proceeded to question him.
What is Shinto?
Shinto? As I understand, Shinto is the national religion of Japan.
Do you give adherence to its precepts?
My father and my mother were Methodists in Japan, and I myself have been a Methodist in this country, and I do not know the precepts of the Shinto religion.
Was not Shinto practiced in your household?
No, sir.
By your father and mother?
It was not, no, sir.
That includes some of the phases of ancestor worship, does it not? You know enough about it to know that.
Yes, if I understand it, that is so.
Does the Emperor of Japan have a religious rapacity?
Well, I'm not really versed enough to say definitely, but I understand that he has, yes.
And do you give adherence to that belief?
I do not. To me, he is a human being.
And you do not accept divine pretensions on the part of the Emperor of Japan?
No, sir, I do not.
Were offerings ever made in the graveyard or before the grave of any of the people of your family?
Offerings? Floral offerings, yes, on Memorial Day and Sundays.
Were there not food offerings placed?
There were no food offerings placed. Both my father and my mother are good, devout Methodists. They're really Christians.
Do you believe in the sanctity of an oath?
I do, sir.
Have you accepted an oath of allegiance to the United States?
I did.
And on that occasion, did you accept some other obligations?
To preserve and defend the Constitution of the United States, yes.
You still hold a commission as a reserve officer in the Army of the United States?
I do.
Is there any obligation on you, under those circumstances, to obey an order of the Commanding General of the Western Command or the President of the United States as Commander-in-Chief of the Armies?
Yes, I believe that there is a certain obligation as an American citizen to respect the Constitution of the United States.
I am not speaking of your obligation as an American citizen. I am speaking of your obligation as a reserve officer in the Army of the United States.
At the time of my active service, I will obey any order of my commanding officer.
You don't think that your oath requires you to obey any order of the Commander-in-Chief of the Armies of the United States until he calls you to active service?
As a private citizen,
I am not talking about your obligation as a private citizen. I am talking about your obligation as a reserve officer of the United States Army. What are the obligations?
I hold myself in readiness for active service at any time, to obey the Constitution and laws of the United States.
And you thought there was no special obligation on you to obey this particular order?
Yes, I took that into consideration, but I feel that after all, this country is dedicated to the proposition that all men are created equal, that every American citizen has a right to walk up and down the streets as a free man, and I felt that these regulations were not constitutional.
If, as a second lieutenant on active duty, you had been given the same order by the commanding general of the Western Department, would you have obeyed it?
I would have, sir.
And what distinction do you make now?
Because now I am a civilian.
And in the event you were on active duty, would you then think it was proper to, by indirection, disobey such a command by invoking other people, Japanese people, to test the constitutionality of this as a law?
No, I would not, because at that time, if I were in active service, I would obey the command of my commanding officer wherever he sent me.
No matter where he sent you?
Yes.
Would you also construe the oath of allegiance to allow you to disobey an order, any order, that was incumbent upon an American citizen?
No, sir, I could not.
I think that is the extent of my examination.
The defendant will rest his case, Your Honor.
The government immediately called a rebuttal witness, a union representative, to testify about labor disputes involving Japanese workers. The government's theory was that the curfew order was a reasonable response to the hostilities that had arisen between white and Japanese workers. Bernard objected.
Your Honor, the fact that there may have been some labor troubles between white people and Japanese would not affect the question one way or the other as to whether the government has a right to discriminate against Japanese citizens because of their race. How the fact that there may have been some isolated labor troubles in some locality between Japanese and white people should justify discrimination against my client, who was not a party to that, solely on the ground of his ancestry. We object to that, wholly immaterial to any issue in the case.
Judge Fee sustained the objection. Undeterred, the government attempted to call yet another witness, a purported expert on the Japanese as a race of people. Yasui was the first of the military order cases to go to trial, but it involved only the curfew. It would set the stage for the more difficult cases to come involving the government's power to intern Japanese Americans in barbed wire camps. The government wanted to test its argument that Japanese Americans, because of their racial characteristics, were more likely than others to engage in subversive activities.
May it please the court, I desire to advise your honor of the availability of a man who is familiar with the Orient, and in particular the Japanese people, a distinguished scholar and educator who is available to testify as to the Japanese as a race of people, and to their ideals and culture and their type of loyalty. Now, this man here is an expert. And in view of the nature of this case, before the government closes its case, I desire to inform the court of the availability of this man.
Well, Your Honor, if this man has any evidence against my client, of course I can't object to it, but I certainly am going to object to any testimony or desertion by some man as to his conclusion as to what some of the Japanese might do under certain circumstances.
Why, I will exclude the general offer. I can't tell from this general offer what the specific matters are to be proved, and if it is just general like that, I have no interest in hearing it. If you wish, put him on the stand, and I will rule on the questions as they come up.
Well, obviously, your honor, the witness has no acquaintance whatever with the defendant. His testimony would deal with the Japanese and their attitude, their race, culture, religion, both here in America and in Japan. I only advise the court of his presence here should his testimony be of interest to your honor.
I might say that I have no interest in this matter at all. You call him as a witness if you want to. and put him on the stand and ask whatever questions you want to. And if the other side wants to object, why, the court will rule.
The government rests, Your Honor.
Although the government elected not to test Judge Fee's patience with its racial characteristics argument, it would press the argument in later proceedings. In 1943, when he issued his final report on the Japanese evacuation from the West Coast, General John DeWitt maintained that the military orders were required because of evidence of espionage by Japanese Americans. He cited hundreds of reports nightly of signal lights visible from the coast and of intercepts of unidentified radio transmissions. These assertions became an important part of the government's military necessity argument. This was so even though two Justice Department lawyers argued in 1943 that the assertions in General DeWitt's report were false. At their behest, the Attorney General asked the FBI and the Federal Communications Commission to investigate DeWitt's charges. These agencies found no evidence that Japanese Americans had been associated with any espionage activity or any illicit signaling. In fact, there was not a single documented act of espionage, sabotage, or fifth column activity committed by an American citizen of Japanese descent or by a resident Japanese alien on the West Coast. Nonetheless, the government persisted in making its military necessity argument to the Supreme Court.
Yasui's trial began in the morning of June 12, 1942, and ended on the same day. Judge Fee reserved decision. Yasui was taken by the Portland Assembly Center, where other Japanese had been detained pending relocation. Yasui remained at the center until September 1942, when he was sent to the newly opened Minidoka relocation camp in Idaho. Minidoka was one of 10 internment camps hastily constructed by the government in 7 states. Upon their arrival in the camps, detainees found themselves imprisoned behind barbed wire fences, watched over by military police and guard towers. Minidoka was so new that there were no running water and no sewer systems. The prisoners lived in rudimentary barracks in the barren desert amidst the sagebrush and the rocks. Families of as many as 9 people lived in single rooms measuring only 20 feet square, furnished with only army cots and a pot-bellied stove.
In November, some 5 months after the trial, Yasui was returned to Portland for Judge Fee to announce his decision. On November 16, 1942, Judge Fee ruled that the curfew order, as applied to American citizens of Japanese descent, was unconstitutional. It was an empty victory, however, because Judge Fee then found that Yasui had renounced his American citizenship because he was a propaganda agent for Japan who chose allegiance to the Emperor of Japan. Because the curfew order could be lawfully applied to aliens, and because Yasui had forfeited his American citizenship, Judge Fee declared him guilty. On November 18, 1942, just 2 days later, Yasui was sentenced.
Mr. Yasui, is there anything you wish to say before sentence is pronounced?
Your Honor, if the court please, I should like to say a few words. There is no intent to plead for your leniency for myself or to request a mitigation of the punishment that is about to be inflicted upon me. Despite the circumstances, I'm compelled to pay tribute and give my unreserved respect to this honorable court for its clear-cut and courageous reaffirmation of the inviolability of the fundamental civil rights and liberties of an American citizen. As an American citizen, it was for a clarification and the preservation of those rights that I undertook this case, confident that the American judiciary would zealously defend those rights, war or no war, to preserve the fundamental democratic doctrines of our nation and to perpetuate the eternal truths of America. My confidence has been justified, and I feel the greatest satisfaction and patriotic uplift in the decision of this honorable court, for it is full of significance for every American, be he humble or mighty. I say that I am glad, regardless of the personal consequences to me, because I believe in the future and in the ultimate destiny of America. I have lived, believed, worked, and aspired as an American. With due respect to this honorable court, in all good conscience, I can say that I have never and will never voluntarily relinquish my American citizenship. The decision of this honorable court to the contrary notwithstanding, I am an American citizen who is not only proud of that fact, but who is willing to defend that right. For I would 1,000 times prefer to die on a battlefield front as an American soldier in defense of freedom and democracy for the principles which I believe, rather than to live in relative comfort as an interned alien Jap. The treacherous attack on Pearl Harbor, the bombing of Manila, and the aggressor policies of the warlords of Japan are just as reprehensible to me as to any American citizen. If America were invaded today, I and 70,000 other loyal American citizens of Japanese ancestry would be eager to lay down our lives in the streets, down in the gutters to defend our homes, our country, and our liberties.
Unmoved, Judge Fee imposed the maximum sentence permitted by law, a fine of $5,000 and 1 year in prison. Yasui was placed in solitary confinement in a small windowless cell for the next 9 months. He would later recount his ordeal.
At first, the guards would not let me out long enough to take a bath or to get a haircut or a shave. At the end of the several months, I was stinking dirty. My hair was growing long and shaggy, unkempt and tangled. My facial hair was growing out in all directions, untrimmed, and my nails were growing so long they began to curl over themselves, both on my hands and my feet. It was not until after Christmas that I was given the permission to take a bath and get a haircut and shave, and that seemed like such a luxury then.
The Ninth Circuit certified the Yasui case directly to the Supreme Court. On June 21st, 1943, the Supreme Court reversed Judge Fee with respect to both his conclusions. It held that Judge Fee had erred in his finding that Yasui had renounced his American citizenship, but it also held that Judge Fee had erred in declaring the curfew order unconstitutional as applied to citizens. In other words, the court ruled that the application of the curfew order to American citizens of Japanese descent was lawful. Although Yasui's status as an American citizen was restored, his conviction was upheld. The same day that it decided Yasui, the Supreme Court decided Hirabayashi. The court accepted the government's military necessity argument and even echoed some of the themes pursued by the government and Judge Fee at the Yasui trial. In his opinion for the majority in Hirabayashi, Chief Justice Stone wrote,
In the critical days of March 1942, the danger to our war production by sabotage and espionage was obvious. Espionage by persons in sympathy with the Japanese government had been found to have been particularly effective in the surprise attack on Pearl Harbor. At a time of threatened Japanese attack upon this country, the nature of our inhabitants' attachments to the Japanese enemy was consequently a matter of grave concern. There is support for the view that social, economic, and political conditions, which have prevailed since the close of the last century, when the Japanese began to come to this country in substantial numbers, have intensified their solidarity and have in large measure prevented their assimilation as an integral part of the white population. In addition, large numbers of children of Japanese parentage are sent to Japanese language schools outside the regular hours of public schools. Some of these schools are generally believed to be sources of Japanese nationalistic propaganda, cultivating allegiance to Japan. We cannot reject as unfounded the judgment of the military authorities and of Congress that there were disloyal members of that population whose number and strength could not be precisely and quickly ascertained. We cannot say that the war-making branches of the government did not have ground for believing that in a critical hour such persons could not readily be isolated and separately dealt with, and constituted a menace to the national defense and safety. The adoption by government in the crisis of war and of threatened invasion of measures for the public safety based upon the recognition of facts and circumstances which indicate that a group of one national extraction may menace that safety more than others is not wholly beyond the limits of the Constitution.
A year and a half later, on December 18, 1944, the Supreme Court rejected Fred Korematsu's challenge to the military order excluding him from the West Coast. The six-member majority, which included Felix Frankfurter, William O. Douglas, and Hugo Black, again relied on the government's military necessity argument. Justice Black wrote the majority decision.
We uphold the exclusion order. In doing so, we are not unmindful of the hardships imposed by it upon a large group of American citizens. But hardships are a part of war, and war is an aggregation of hardships. All citizens alike, both in and out of uniform, feel the impact of war in greater or lesser measure. Citizenship has its responsibilities as well as its privileges, and in time of war, the burden is always heavier. Korematsu was not excluded from the military area because of hostility to him or his race. He was excluded because we were at war with the Japanese Empire, because the properly constituted military authorities feared an invasion of our West Coast, and felt constrained to take proper security measures because they decided the military urgency of the situation demanded that all citizens of Japanese ancestry be segregated from the West Coast temporarily. And finally, because Congress, reposing its confidence in this time of war in our military leaders, as inevitably it must, determined that they should have the power to do just that.
Justices wrote dissenting opinions, including Justices Murphy and Jackson.
The exclusion of all persons of Japanese ancestry, both alien and non-alien, from the Pacific Coast area on a plea of military necessity in the absence of martial law ought not to be approved. Such exclusion goes over the very brink of constitutional power and falls into the ugly abyss of racism. I dissent. Racial discrimination in any form and in any degree has no justifiable part whatever in our democratic way of life. It is unattractive in any setting, but it is utterly revolving among a free people who have embraced the principles set forth in the Constitution of the United States.
Korematsu was born on our soil, of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim has been made that he is not loyal to this country. Korematsu, however, has been convicted of an act that is not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born and where all his life he had lived. A citizen's presence in the locality was made a crime only if his parents were of Japanese birth. Had Korematsu been one of the fourth, the others being, say, a German alien enemy, an Italian alien enemy, and a citizen of American-born ancestors convicted of treason but on a parole, only Korematsu's presence would have violated the order. The difference between their innocence and his crime would result not from anything he did, said, or thought different than they, but only in that he was born of different racial stock. Now, if any fundamental assumptions underlies our system, it is guilty is personal and not inheritable. But here is an attempt to make an otherwise innocent act a crime merely because this prisoner is the son of parents as to whom he had no choice and belongs to a race which there is no way to resign. I would reverse the judgment.
Yasui was released from Minidoka in 1944. After the war, he was moved to Denver, Colorado, where he practiced law and worked in civil rights. In 1946, he married True Shibita.
Yasui's conviction stood for more than 40 years. In 1984, the federal court in Oregon granted Yasui's petition for a writ of coram nobis, vacating the conviction. Yasui had also asked for a declaration that the government had engaged in misconduct and that Public Proclamation No. 3, the curfew order, was unconstitutional. The court denied this relief. Undeterred, Yasui appealed to the Ninth Circuit. He did not believe the vacating of the conviction was sufficient vindication. On November 12, 1986, while his appeal was pending, Minoru Yasui passed away. The Ninth Circuit granted the government's application to dismiss the appeal as moot. Yasui's fight for justice had come to an end.
Thank you everyone for joining us for this year's trial reenactment. We hope this performance inspires all of us to take courage and stand up for justice, even in the face of adversity. We learned about what happens when prejudice replaces principle. We also learned how, despite injustice and adversity, that we can be inspired to carry on towards justice and humanity. At KACE, we emphasize the importance of remembering these moments as history, as vital to make sure these injustices do not happen again. Through this trial, race-based curfews and internment camps happened approximately 80 years ago. We still continue to face racism, discrimination, and xenophobia, not in just rhetoric, but unfortunately in government policy. We must continue to remain courageous and vigilant to make sure this true justice prevails. By remembering our history, we are reminded that justice ultimately prevails as long as we continue to do the work. Thank you everyone again for this time of learning, remembering, and being inspired to persevere in the path of justice. Get home safe and have a good rest of your evening. Thank you.
Internship Program.